You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and I'm excited to continue our Explain series today, where we're breaking down the United States fundamental environmental laws. Today, we'll be talking about the National Forest Management Act. I'd like to welcome our two wonderful guests, Susan Jane Brown and Martin Nie. Thank you for joining us today.
Thanks for having us.
Thank you, Sebastian.
Why don't you go ahead and briefly introduce yourselves for our listeners?
Sure. So I'm Susan Jane Brown. I am an attorney with Silvix Resources, which is a nonprofit environmental law firm focused on federal forest law, policy, and collaboration. I am based in Oregon and split my time between the west side of the Cascades in Portland, Oregon, and the east side of the Cascades in John Day, Oregon. But my practice does take me across the western United States and into our nation's capital in Washington, D.C.
Yes, I'm Martin Nie. I am director of the Bolle Center for People and Forests and a professor of natural resources policy at the University of Montana. Been teaching here going on 25 years now.
And I should probably add, since Martin is also a professor, I am an adjunct professor of law at Lewis and Clark Law School, where I teach forest law and policy. And I've been teaching that class for 17 years now.
Fantastic. Thank you both. Sounds like we've got the right people on this podcast today. Maybe we can get started doing a quick primer on the National Forest Management Act, or NFMA, or NFMA. Could you tell us a little bit about why it was created?
Sure. As with a lot of federal legislation, there's a sort of long, protracted history that leads up to congressional enactment of a law. One of the main impetus for the enactment of the National Forest Management Act began with the clear-cutting controversy, which, for those who don't know, clear-cutting is a forest management practice whereby every tree from an area that's been designated for harvest is removed. And it's generally a very economically efficient practice, but it also has pretty significant environmental consequences. But leading up to and after we won World War II, and you had a bunch of GIs who were returning home from the war, there was a need for an increase in housing. And the federal forests were now seen as a place of raw wood products that could be used to build new homes for returning GIs. And so the Forest Service, which manages 193 million acres of federal land, most of which is forested, got into the action and said, we can help with that. And we can increase the amount of timber harvest that we're doing on the national forest to serve that public interest in building homes for returning war veterans. And so we started to see in the late 1960s an increase in timber harvest that was happening on federal forests, particularly clear cutting. And that clear cutting started to have pretty significant ecological consequences. So in the 1960s, Senator Lee Metcalf asked Arnold Bolle, who was with the University of Montana, to take a look at the clear cutting practice and to issue a report on it. And the Bolle report came out in 1970. It was very critical of clear cutting because of the ecological implications. That report was followed by a second report in 1972 called the Church Report, which was named after Senator Frank Church, that was also very critical of clear cutting. Those reports were designed to influence congressional action around clear cutting, but that was unsuccessful at the time. So we had this rise in this controversial practice, but no congressional action. But Congress was paying attention to some other things, and in 1960 enacted the Multiple Use Sustained Yield Act, also known as MUSIA or MUSI, depending on how you pronounce it. And in the 1960s, we also had the rise of the environmental movement and growing conflict between conservation of natural resources and utilization of those natural resources. And this was starting to become a difficult situation for the Forest Service. And so the Forest Service went to Congress and said, hey, we would really like for Congress to give us some direction about how to balance these uses, whether that's timber harvest or mineral development or hunting and fishing, that sort of thing. So how do we balance all of these uses that we're finding on our national forests? And the response to that from Congress was the Multiple Use Sustained Yield Act of 1960. And what we saw with the Multiple Use Sustained Yield Act was the first real intentional attempt by Congress to balance multiple uses. And it says that the management of all of the various renewable surface resources of the national forests should occur and should be utilized in the combination that will best meet the needs of the American people, which is a really vague definition. It really doesn't tell the Forest Service how to balance those multiple uses. And because of that, we saw some early litigation in the 1970s that tried to really flesh out what multiple use meant. But those early cases in the 1960s didn't give anyone any answers about how to balance those uses. So the Forest Service, frustrated again with the lack of concrete direction from Congress, went back to Congress in 1974 and said, hey, can you try again, Congress? MUSA didn't really work for us. And so Congress tried again and enacted a very long-winded piece of legislation called the Forest and Rangeland Renewable Resources Planning Act of 1974. This statute was supposed to give the Forest Service the ability to plan on multiple year increments as opposed to every year, which is the annual appropriation cycle. And it's very difficult, actually, to manage forests and grasslands on a yearly basis. You actually need to plan on a much longer horizon than annually. So the Renewable Resources Planning Act was supposed to allow the agency to plan for the management of those lands on a longer time horizon and also try to provide some additional direction to the Forest Service about how to balance those multiple uses. Unfortunately, the Renewable Resources Planning Act also was not successful, and we had some additional litigation in 1975 called the West Virginia Division of the Isaac Walton League of America v. Butts. And this case is also known as the Monongahela decision after the national forest that was the center of the litigation. The plaintiffs in this case were unhappy with clear cutting. We talked about the clear cutting controversy. Plaintiffs didn't like clear cutting. And the federal defendants, who was the Secretary of Agriculture, said, well, look, we've got the Multiple Use Sustained Yield Act. It allows us to balance all these multiple uses. And in our discretion, we balance these multiple uses on the Monongahela National Forest and decided it was still okay to clear cut forests to produce timber. However, that decision caused quite a bit of consternation within a lot of stakeholders, the public, Congress, and the timber industry. And the timber industry and the Forest Service went to Congress one more time and said, hey, look, please give us more direction. And what came out of that was the National Forest Management Act of 1976.
SJ, that was wonderful. To zoom out even a little more in keeping with SJ's narrative here, I would go back to the foundation of national forest law in the 1897 Organic Act that gives to the Forest Service this really broad discretion in terms of watershed protection, a continuous supply of timber, direction to improve and protect the national forests. And so the sort of way that I teach NFMA is to kind of begin there with like the agency having considerable discretion. And then we get to the environmental era in the 1960s and 70s. And we slowly start to see Congress take away some of that administrative discretion. We see passage, for example, of the Wilderness Act of 1964, which is basically like a course correction to the Forest Service, saying, we're not going to trust you to manage roadless and primitive areas. The Multiple Use Sustained Yield Act, as Susan Jane references, is a good example of that. It was designed as a course correction for the Forest Service that was starting to focus more on timber harvesting than other uses. And so fast forward to 1976. In light of the controversies on the Monongahela and the Bitterroot National Forests here in western Montana, we see yet again this course correction by Congress saying that we're going to find some sweet spot between enforceable standards, this new mandate to plan for each one of the national forests, and also room for the Forest Service to exercise its professional expertise in forestry. And out of that mix, I think we get the NFMA.
Yeah, I think that's spot on. NFMA was a congressional response to the Monongahela decision, where in that case, the court actually did stop the Forest Service's practice of clear cutting and really questioned the Forest Service's discretion and their expertise in forest management. Forest Service was very unhappy with the Monongahela decision, did not like having their discretion and their expertise called into question. And so with NFMA, Congress again tried to reset things a little bit. For our purposes, the National Forest Management Act is a really interesting statute. It's got a whole bunch of different niche things going on with it. But I think big picture, what it does is it requires planning. It requires the Forest Service to work with the public and other experts to plan for forest management into the future. And it does that through the requirement to prepare what are called land and resource management plans, also known as forest plans or land management plans. But they are big planning documents. And you can think of them just as you would think of, county or city zoning. Where are we going to do what? Also, in addition to zoning, forest plans include management direction. So in those riparian areas that surround aquatic features, how do we manage them? What do we do and what don't we do? NFMA envisions direction in these forest plans that say, do this and do not do that. So they are red lights and green lights, and also a fair number of yellow lights. And so your forest plan, again, is a large zoning exercise and a key feature of how we manage our national forests.
Thank you all so much for that overview of the National Forest Management Act and how it got started. And I think we started to touch on something a little bit that we wanted to expand on for our listeners, which is that the National Forest Management Act is different from some of the environmental statutes that people might be more familiar with, like CERCLA or the Clean Water Act, because the regulated entity in this case is not a polluter or the private sector, it's the government itself. Is that correct?
Yeah, that's right. It is different because it speaks to how the federal government is allowed to provide for the provision of multiple uses. So unlike the Clean Water Act, which directly regulates non-federal actors, for example, utilities or industrial point sources, the National Forest Management Act generally regulates the federal government and by extension, those users of that raw material. So in telling the Forest Service how to manage forests, by extension, it also tells prospective buyers of the ability to harvest that timber how to do it and where to do it. It's a little bit different than your usual environmental laws that we typically deal with.
Yes, and I would add, it's hard to motivate students to learn about forest planning. I think there's some dread at that point of the semester, Susan Jane, when you see these big voluminous forest plans with 18 appendices and so forth. And the way that I start that unit every semester is with the so-called consistency provision in the NFMA. And this is like the so what, who cares part of the statute. And it says clearly that all plans, permits, contracts, uses, any occupancy, public or private, on the national forest has to be consistent with the governing forest plan. And so they are just these critical documents that guide essentially everything that happens on a unit for 10 to 15 or more years.
Yeah, I think that's totally right. And, because who wants to go read their county zoning laws? Like nobody wants to do that. It's very confusing. It does involve its own language, if you will. And forest planning is very similar. It has its own vernacular. It is pretty science heavy. It's pretty technical in nature. And that can be a real turnoff for folks, whether you're a student or a member of the public who just wants to know where they can go hunt and fish and camp.
And I think that'll be useful for our listeners to understand the difference, but also the value in that difference and why this law is so important to our national forests and in turn to the country as a whole as a provider of natural resources. Moving on a little bit, I wanted to cover for our listeners whether these goals are protective of forest or are they more so meant to be economic in nature? So are the goals more so management to ensure the continuity of the forest, or are there ecological considerations that go beyond the economic purposes?
Ooh, that's a good question. I think the answer to that depends on your perspective. Congress was certainly concerned that unwise utilization of natural resources, particularly those owned collectively in common by the American people, that we needed to steward those resources wisely. In fact, the first chief of the Forest Service, Gifford Pinchot, was very much a utilitarian, and his catchphrase was managing these forests for the greatest good for the longest periods. That said, there is an element of conservation and protection and preservation in the various multiple uses, including, for example, wilderness. Wilderness is not really a renewable resource and it must be preserved. And that is one of the multiple uses that is specifically mentioned in NFMA. So it's kind of an uneasy balance between preservation, utilization, and conservation. It's a little bit of all of the above. What do you think about that, Martin?
I agree. I mean, Sebastian, the legislative history is fascinating. It's just this really rich dialogue that happens between Chief McGuire at the time, Senators Randolph and Humphrey and Church, constantly going back and forth. I mean, clearly Congress wanted to deal with those localized forest disputes, those conflicts on the Monongahela and the Bitterroot. There's national level concern about the amount of timber harvesting taking place, clear-cutting practices, the terracing techniques on the Bitterroot. And that legislative history shows this sort of dialogue that, well, how can we retain the sort of expertise of the Forest Service while at the same time providing substantive, enforceable constraints on the agency? And I'll go back to the Multiple Use Sustained Yield Act, right, which is really the governing principle given to the Forest Service in 1960, these 5 uses that are both economic and conservation oriented. And up until 1976, the Forest Service had considerable flexibility and discretion in how they balanced all of those uses. And so the famous example, Sierra Club v. Hardin, 1971, on the Tongass National Forest in southeast Alaska, the district court upholds a 8.7 billion board foot timber sale in southeast Alaska that would have cut something like 95 to 99% of all the suitable timberlands. And that was upheld as a legitimate construction of multiple use. So too is the roadless rule. I mean, setting aside 59 million acres, not building roads. The court said, that's the discretion built in to multiple use management. And so the NFMA, right or wrong, if it did the trick, we don't know. There's some debate, but it tries to find that balance, right? That we're going to sort of rein in the agency. The way we're going to do this is to mandate the Forest Service prepare a specific plan for a specific place. And it is going to be based on an inventory of resources. 2, it's going to be done in an interdisciplinary fashion. So it's not going to just be road engineers. It's not going to just be silviculturists. It's going to be this sort of interdisciplinary exercise. It's going to be done pursuant to NEPA. So we're going to have an alternatives framework and so forth. And then it provides a series of constraints on the agency. It didn't say no clear cutting, but it said if you do clear cutting in the future, you have to meet these following criteria with regards to soil, slope, riparian protections, the economics of it all. And then most important, I think one of the biggest contributions of the NFMA is its wildlife diversity clause, which is really one of the most substantive provisions in all of federal public lands law, other than the Endangered Species Act, that again tries to reinsert wildlife, make it a controlling, co-equal factor in the administration of our national forest lands.
Thank you both. That was a really helpful walk through the history and context of the NFMA. This might also be the perfect place to pivot into the next big question. How exactly is a forest plan created? The requirement for forest-wide planning is one of the real hallmarks of the NFMA, but what does it look like in practice?
So, as we mentioned, one of the hallmarks of the National Forest Management Act is this requirement to engage in forest-wide planning and to develop a forest plan for each unit of the national forest. So your favorite national forest has a forest plan. The statute also required the Forest Service to promulgate 2 sets of regulations. One, a set of regulations to guide the development, amendment, and revision of forest plans, and also to develop a set of regulations regarding the administrative review of those forest plans and of projects that implement those forest plans. So you've got a set of regulations having to do with planning, and you've got a set of regulations having to do with administrative review of plans and projects implementing plans. So those planning regulations have a bit of a tortured history, and I think for your viewers' purposes, there's probably 2 things to keep in mind. One, the set of planning regulations that most of our national forests used to develop their forest plans were promulgated in 1982. And those first round of forest plans were generally developed in the late 1980s, early 1990s. The statute requires forest plans to be revised every 15 years, which makes a ton of sense because things change. Socioeconomic settings change, ecological settings change, public demands of these forests change. And so every 15 years, we should take a look and we should revise our forest plan. The statute requires that. And the regulations were designed to facilitate those revisions and amendments and changes to forest plans. That said, the Forest Service is really bad at it. And I think Martin would probably agree, and I think most forest planning nerds would agree, that the Forest Service is just not very good at planning. And those forest plans that were originally developed in the late 1980s, most have not been revised. So most of our national forests are being managed according to forest plans that were developed based on a set of regulations promulgated in 1982. That's before the internet. That's before GIS. That's before the advent of climate change. So a lot has changed since the late 1980s. The Forest Service did manage to revise their planning regulations after a long bout of back and forth in the courts in 2012. And Martin and I were both appointed to a federal advisory committee by the Secretary of Agriculture in 2012 to assist the Forest Service in implementing the 2012 planning rule, which I think in our view is really an amazing accomplishment in terms of regulatory creation. And the way that I talk about this with my students is if the 1982 planning rule was a Yugo and it got us Yugo-based forest plans, the 2012 planning rule is a Ferrari. It has all kinds of bells and whistles in the 2012 planning rule. It embraces concepts such as ecological integrity, which is a way of evaluating landscape health. It does also include a very robust approach to wildlife diversity and biodiversity. It also requires a whole lot of monitoring and adaptive management, as well as doing things like producing timber and forage and minerals and other natural resources off of our national forests. So the 2012 planning rule is what the Forest Service is using today to amend and revise its forest plans, although that is a very long road. And as I said, most of our forest plans have not been revised since the 1980s, and the Forest Service is very, very slowly working through the very long list of forest plans that need to be revised using the 2012 planning rule.
So, since the 2012 rule is what's guiding updates today, could you maybe walk us through what that process actually looks like when a forest begins a revision?
One of the things that the 2012 planning rule does is it describes the planning cycle in a way that the 82 rule did not and the statute did not. And it starts with assessment. And the assessment process is what it sounds like. It's where we go out there in each national forest. And the way that the forest planning revision process begins is by assessing existing conditions on the ground. Out of assessment come a whole series of reports that say, okay, how are our aquatic resources? How is our rangeland? How are our forest resources based on information that we know? The assessment reports then are collected and yarded up. And out of that comes the need for change analysis. The need for change tells us what's working and what is not working. And that is what the revision process focuses on, are those things that need to change. The 2012 planning rule provides quite a bit of detailed explanation and direction about when things need to change, how to change them, and the considerations that need to go into making those decisions about change through that interdisciplinary approach that Martin mentioned. So we get all of our ologists together and we say, okay, so based on our monitoring reports, we have a decline in elk populations on this forest. What's causing that decline in elk populations? Well, what we know based on our monitoring and the academic literature that has occurred on the Malheur National Forest, we know that we have too many roads on this forest. And when you have open roads, elk tend to avoid them. And elk instead find sanctuary not on the national forest, but lower down in elevation on private lands. So what do we need to change? Well, we need to lower the road density on the Malheur National Forest so that we can get elk off of the private lands onto the national forest lands, onto the public lands where they really belong, so that we can better manage those wildlife populations that the statute and the regulations tell us we need to manage for. So the revision process would make those changes, and we would develop new plan components, standards, guidelines, objectives, desired conditions, goals for how to achieve that desired condition of having elk where they belong on the national forest with reduced road density so that they are not trespassing on private lands down below, right? We revise our forest plan accordingly. The next phase in the forest planning process is implementation. So we revised our plan, we implement it, and then we monitor it. So we actually have monitoring provisions in our forest plan that look at, okay, so we made this change. We lowered road density to get elk off of private and onto the public lands. Did it work? Did it not work? Why or why not? That monitoring piece is really critical so that we know whether our revised forest plan is working for us. If it's not working for us based on our monitoring, then we need to adapt. And that's the adaptive management cycle. So that's the forest planning process in a nutshell.
Susan Jane, thank you so much. That's a really helpful summary for our listeners of how these plans were created and are now being revised through this new planning cycle that was in the 2012 rule. Before we move on, I'd love to circle back to something one of you mentioned earlier, which is the wildlife diversity clause. It sounds like that provision of NFMA has been especially influential. Martin, could you maybe explain what that clause requires and why it's considered such a cornerstone?
So the NFMA has a provision that calls for providing for the diversity of plant and animal communities based upon the suitability and capability of the specific land area in order to meet overall multiple use objectives. So this is both a substantive and a procedural requirement to provide for diversity of wildlife. Right off the bat in 1979, there's some discussion of how do we actually interpret this new diversity clause. And in 1982, this task was given to a formed committee of scientists. And the way they put this into operation was calling for the viability of wildlife populations. Environmental litigators like Susan Jane and others have used the NFMA diversity and viability provision to challenge all sorts of management activities on the national forest system. It has been a very sharp tool for environmental plaintiffs and wildlife advocates.
That's right. And the diversity provision, it is a centerpiece of the 2012 planning rule and does definitely speak to the importance of wildlife to the American public. We think it's important. And so we're going to make sure that we regulate it and do the right thing when it comes to wildlife that folks care about. You see a bit of a shift from the 1982 planning rule, which really focused on individual critters themselves as members of a wildlife population. We shifted in the 2012 rule to focus more on habitat, with the idea being if we have sufficient habitat of high quality for critters, then the populations of those critters should respond accordingly. In the 2012 rule, this is known as the coarse filter and the fine filter approach. And the regulations require forest plans to include plan components, standards, guidelines, objectives that maintain or restore rare plants and animals in their habitat, as well as key characteristics associated with various ecosystem types. So, for example, in my ecosystem here, it's a ponderosa pine ecosystem. We need to make sure that we have frequent fire to maintain those ponderosa pine forests in order to provide wildlife habitat for goshawk, for example. So that's a coarse filter. The 2012 rule also recognizes, though, that some critters are really special. They're kind of unique snowflakes, and they require certain specific habitat characteristics that we may not automatically provide for if we're just managing large ecosystems. So those fine filter plan components are put into place when a coarse filter approach is not sufficient. Fine filter plan components might look like make sure that you retain large diameter snags near waterway, because certain bat species that are species of conservation concern, meaning that their populations are not secure, those critters need that particular type of ecosystem feature. And so we need a fine filter to make sure that we retain those and provide for those kinds of unique habitat features when we're out there managing the land for other multiple uses.
That is absolutely fascinating, Susan Jane, and I think will really give our listeners a much better idea of how specific these plans can get, and I think a greater appreciation of the value that they have for our national forest as well. Now, I want to take a step back a bit and talk about who is actually involved in creating these forest plans. At the federal level, of course, but also regionally and locally. And on top of that, what kind of accountability is there if the Forest Service doesn't follow through on the planning requirements?
That's such a good question, Sebastian. I think right from the get-go, there's been this long-running theme or debate in forest planning that goes back to 1976, really. It's the top-down versus bottom-up question in terms of how to influence management on a particular unit. I think there's some of us in our camp that feel like what we need in a plan is some assurances for how lands are going to be managed, how to resolve particular conflicts between, say, grizzly bears and sheep. Is this particular area suitable for livestock? Is it suitable for timber? We look at plans to provide meaningful guidance and some enforceable constraints on the agency. And then there are others, a lot of Forest Service personnel that understand that argument, but they err on the side of providing administrative flexibility and discretion. And they'll often argue that, the world is too complex, too dynamic, too fluid to make those sorts of commitments that you want on the ground. This is often done in the name of adaptive management. But there is this theme in planning, and I think we see it in the revision of plans today. And there's got to be some sweet spot in there because clearly we need to retain some flexibility and discretion. But at the same time, I think they need to provide some substance and some real decisions in a plan. Otherwise, why participate at all? And your first question, Sebastian, about public participation. I run this small little center called the Bolle Center for People in Forests, and it was named after Dean Arnold Bolle of the Bolle Report. But at the root of the so-called Bolle Report was a scathing critique of the lack of public participation in national forest management. It was like the central theme in the Bolle Report and subsequent writings. The task force essentially argued that the Forest Service had become an anti-democratic organization, treating locals as antagonists. And one of the famous contributions of the Bolle Report was this advocacy for meaningful, substantive public engagement in planning.
Yeah, I think that's really important because these are public lands that are owned by all Americans. And so we all have a stake and have an interest in how these lands are managed. So the focus on robust public engagement around building plans and then subsequently implementing those plans makes a whole lot of sense. I mean, these are our lands. And so we should have a say, as should tribes, sovereign nations, states, other governments. So all of these kinds of stakeholders should be part of this process. By their very nature, and by NFMA's very nature, we have promised to be all things to all people all of the time on our national forest because they are multiple use lands. And that becomes a very difficult political environment in which to navigate because, again, everyone's coming to the table and everybody's bringing their interests and they're going to advocate for those interests. And sometimes those interests align and overlap, but oftentimes they don't. And if you're a land manager, if you're the Forest Service and you're trying to figure out how to navigate that, then you're going to want to rely on your discretion and deference to your decisions and how you decide to best balance those multiple uses and those multiple demands. And to your second question, Sebastian, about how do we force accountability, that's also a really good question. And I'm a lawyer, so I'll answer it as a lawyer first. You go to court. The Forest Service, has made a decision and you've got a forest plan that says thou shalt do it this way. And if you've got advocates who don't believe that that's happened, then you go to court and you ask a judge to decide. And the judge will evaluate whether or not a project complies with the plan based on that consistency requirement that is both in the statute and in the regulations, meaning that projects must comply with the provisions in forest plans. So those forest plan provisions need to be concrete, they need to be objective, they need to be measurable, they need to use plain language so that everybody knows what they mean and everyone can evaluate whether or not we are meeting those requirements. And that does force some accountability. But again, if you're a line officer and you're confronted with trying to manage all of these various stakeholder perspectives, you're going to want to have a forest plan that's actually pretty squishy, that lets you make those decisions on a case-by-case basis. My perspective is that we will continue to fight over how best to manage and balance those uses as long as we have multiple use statutes that guide the management of those lands. So until we amend or repeal and replace the National Forest Management Act, which is a multiple use statute, I think we will continue to have these very robust disagreements about how to manage these lands.
Thank you, Susan Jane, and thank you, Martin, for breaking that down. It really highlights the ongoing tension in how these forests are managed. It might be helpful now to shift to the legal side. NFMA has been around for almost 50 years, so there have been some court cases testing how it works in practice. Could one of you talk about some of the cases that have shaped how the Act has been implemented and interpreted?
So in terms of court cases, there have been a long series of court cases that have interpreted initially the statute, the National Forest Management Act itself, but really most of the case law has been interpreting the regulations in the context of site-specific projects that are implementing forest plans. And most of the case law that we have out there is case law that was developed under the 1982 planning rule. And most of that case law focuses on the diversity requirement and whether or not a particular project, usually forest management, but sometimes road construction, mining, other types of development, and how they affect wildlife habitat and wildlife populations. In general, what you typically see in the case law is that the Forest Service does have this obligation to manage wildlife habitat, to provide for viable populations of wildlife species. But where courts draw the line on the agency going too far or not far enough is pretty site-specific. And it involves both the forest plan at issue and how it was written, and it involves the specific timber sale at issue and how the agency went about documenting their compliance with their forest plan. We also typically see National Environmental Policy Act, or NEPA, claims wrapped up in those substantive NFMA claims. So did the Forest Service disclose and describe the environmental consequences of a timber sale on a at-risk wildlife species? So that's typically what we see in the case law. With the 2012 planning rule, which did change some of those requirements, we haven't seen a lot of forest plans revised under the 2012 planning rule yet. And so we haven't seen a lot of case law looking at and evaluating the 2012 planning rule. So we are still generally seeing court cases that are interpreting old forest plans and old regulatory language. And it's a bit of a mixed bag. Generally speaking, the Forest Service does win most of those cases, but it depends on where those cases are brought. There have been a couple of seminal cases involving forest plans, one being Ohio Forestry, which is the name of the plaintiffs in that case. Another is Southern Utah Wilderness Alliance v. Norton, which was another case having to do with motorized use. And they were both Supreme Court cases. So in Ohio Forestry, the court was evaluating whether or not a challenge to a forest plan was right. The plaintiffs in that case, which were initially in the lower courts, conservation organizations, brought a challenge to a forest plan without also bringing a site-specific project challenge as well. So they brought a facial challenge to the forest plan. And the Supreme Court, in what I think was very convoluted language that was wrong, held that forest plans, generally speaking, are not ripe for judicial review absent some sort of site-specific subsequent decision that fleshes out whether or not those forest plan provisions are lawful under the National Forest Management Act. So looking at a forest plan, you can't really tell, the Supreme Court said, whether or not that forest plan complies with NFMA. And instead, you need a site-specific project, a timber sale, a special use permit, what have you, to determine whether or not a forest plan complies with the National Forest Management Act. So there's this question about ripeness. Are forest plan challenges ripe? And the way that I think Martin and I look at that question of ripeness is the Supreme Court, Justice Scalia also said in Ohio Forestry that we're not really sure that forest plan challenges are ripe, but if you can identify a procedural violation, for example, a NEPA violation, then that is immediately ripe. We can tell right off the bat whether or not the Forest Service followed the right process. We can't tell right off the bat if they followed the right substance. We're going to need a project to determine that. But process, we can figure out. So process challenges to forest plans may very well be ripe. So that's Ohio Forestry. Southern Utah Wilderness Alliance v. Norton, or SUA v. Norton, is similar and looks at whether or not forest plans substantively create enforceable requirements. And at issue in SUA was whether, and this was actually evaluating a Bureau of Land Management plan, not a Forest Service plan, but for our purposes, they're basically the same thing. They just come about through different statutes. But in evaluating this BLM plan, the Supreme Court was evaluating whether or not a provision that prohibited the unnecessary and undue degradation of public lands was met when the BLM refused to take action based on monitoring to close off-road vehicle routes that were compromising the ecology of that area. So we had monitoring data that revealed that off-road vehicle use was compromising wildlife habitat and aquatics, and we should maybe move that route or close that area to that use. And the Supreme Court there held that that forest plan provision that prohibited unnecessary and undue degradation of public lands was not specific enough to create a mandatory enforceable obligation on the part of the BLM. I think that case was also wrongly decided. I don't think it makes a whole lot of sense from a practical standpoint, but we do have these Supreme Court precedents that are out there that do dictate when and how judicial review of forest plans and their provisions is viable.
Thank you, SJ, for providing kind of that overview of what's been brought to the courts in terms of case law that's been developed, as well as some of the more important Supreme Court cases that laid the groundwork for what kind of challenges and when can challenges be brought. To kind of wrap up, I just wanted to ask you both, what are some future developments to watch regarding NFMA, specifically in regards to maybe some of the recent executive orders relating to U.S. timber goals? And I'm also curious, a recurrent theme throughout the episode has been the struggle to kind of update the forest plans in general, but specifically since the 2012 rule. And I'm curious to hear a little more about what to watch with respect to the updating of these plans that haven't been updated in so long.
So I think a couple of things to keep an eye on. One is Forest Service capacity. The Forest Service has lost, by some counts, more than 7,000 employees over the past 6 months through forced retirements, early retirements, and the like. And the Forest Service is not a huge organization to begin with. And when you lose that many staff that quickly, you lose a lot of institutional knowledge and you lose a lot of planning expertise. And we've also limited the agency's budget in terms of the rescissions law that clawed back billions of dollars, some of which was being used for planning and for forest plan revision. So you have an agency that is cash strapped and now is down agency capacity as well. So whether the Forest Service has the capacity to do anything, whether that's fight fires or build trail or clean outhouses or revise forest plans, is a very open question. I think it will be very interesting to see what, if anything, the Forest Service is able to do over the foreseeable future, given their capacity constraints. Another thing to keep an eye on is forest plan revision. There is a queue, meaning a list of forests that are in the queue for revision. It's a very long list, and the Forest Service is not moving through it very quickly. That said, the chief of the Forest Service, Tom Schultz, who, interestingly enough, is the first chief in Forest Service history that has no experience working for the agency. Before now, all chiefs have come from the ranks. They've spent time working for the Forest Service. Our current chief does not have that expertise, but one of his priorities is implementation of forest plans and forest plan revision, which is great. That's something I support because I think our forest plans are outdated and should be updated. But without money or people, it's hard to know how that happens. And then there's the implementation of this administration's timber dominance policy agenda that you mentioned, Sebastian. There's a lot of policy direction in the form of executive orders to increase timber harvest. We saw that in the reconciliation bill as well, to increase timber harvest. But again, without people and money, it's really hard to see how any of that happens. I think the other important piece here is that forest management in timber production is an international market, and it's affected by things like trade wars and tariffs. And so what we do here domestically has to do with what happens internationally in the market and whether or not there is any demand for an increase in timber production. Same thing with workforce and actual infrastructure. We have a declining workforce that works in the woods, and we have declining mill infrastructure in the West, particularly here in Oregon and in Montana. And if you don't have workers in the woods or a place to take those logs, if you don't have a mill to mill them into 2x4s, nothing is going to happen. And so while I am very distressed by the rhetoric that's coming through this administration, I think there's also some very cold, hard realities around implementing that mandate that the Forest Service has yet to wrestle with. Martin, what would you say?
I thought that was really good, Susan Jane. It's certainly the most chaotic time in my career trying to make sense of what are really sort of existential issues for, I think, our public lands and our national forest system. Certainly, I see it as sort of unprecedented threats to the institution itself, to its science and research capacity, its personnel, its identity. So I have grave concerns. And, I spend a lot of time with multiple use, right? And whether it's Bureau of Land Management or the Forest Service, I think when you work in that field, you become comfortable with the degree of conflict and tension that is just baked into the entire endeavor. We live in a democracy, and these planning processes are messy, and there's, by statute, these tensions and trade-offs that are to be resolved in a plan and a unit level. So, I get that, but what we've seen, these extreme pendulum swings from one administration to another, and things will swing back, maybe in unpredictable ways. And I think at the end of the day, our public lands, our national forest system, our rural communities, our fish and wildlife don't benefit from such dysfunctional politics and extreme pendulum swings.
Totally agree.
Thank you both so much.
Thank you for the opportunity. I really appreciate the work that ELA does, kind of demystifying some of these statutes. So thank you for the opportunity.
Yeah, that was a lot of fun. Thanks for having me.
As we've seen this episode, the National Forest Management Act established a framework for balancing multiple uses of public lands, requiring long-term planning, public input, and accountability. Nearly 50 years later, it continues to guide how the Forest Service manages forests and navigates competing demands. Thank you for listening, and we hope you'll join us for the next episode in our Explain series on People, Places, Planet, where we're breaking down the laws that shape our environment one statute at a time.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.